Good afternoon and welcome to today's presentation, Issues Involved in Custody Suicide Litigation. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the expert. All materials obtained from this presentation are merely for educational purposes and should not be used in a court of law sans the expert's consent, i.e. a business relationship where she or he is hired for your particular case. In today's webinar, Dennis will discuss threshold questions, foreseeability, standards of care, causation, and statistics. To give you a little background about our presenter, Dennis M. Savard has been a practicing forensic criminologist for nearly a decade. Dr. Savard has developed expertise in crime analysis, research on standards of care, and analyzing foreseeability issues involving security, law enforcement, and corrections. He has been involved in cases pertaining to premises liability, law enforcement, and corrections. He has published academic peer-reviewed articles and book chapters on jail suicide, workplace violence, crime at shopping centers, correctional counseling, security prevention measures, women as victims of crime, forensic criminology, and excited delirium. He is president of Forensic Criminology Consultants and an assistant professor of criminal justice at Saginaw Valley State University in Michigan. Attendees who require a passcode, the word for today is custody. During the Q&A session, we ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Tomorrow morning, we will send out an email with a link to the archived recording of the webinar. The slides can be downloaded from the resource list at the widget at the bottom of your screen. Thank you all for attending today, and Dennis, the presentation is now turned over to you.
Thank you, Lauren. I appreciate that. Hello, everybody, and thank you for attending our webinar today. At the onset, I just want to quickly mention I am just recently getting over the flu, so I do apologize if I seem a little stuffy at times. But with that said, the title of my presentation today, as Lauren just mentioned, is Issues Involved in Custody Suicide Litigation. And where we initially would like to start is this idea of threshold questions. And with respect to this question and focusing on it from a plaintiff's point of view, you simply want to decide, or the plaintiff needs to decide, whether or not this is going to be a federal or state case or both. For example, as I'm sure most of you know, there's something called Section 1983 litigation. And of course, these are federal civil lawsuits arising out of allegations such as depriving an individual of his or her constitutional rights. Indeed, Section 1983 provides remedies for violations of federal rights, and Section 1983 lawsuits can include a variety of claims of abuse of authority by both police and correctional personnel when we're either dealing with a person who has been arrested, for example, by the police, or a prisoner who is currently confined in a prison or a jail. And then, of course, from the defendant's point of view, they need to decide whether or not they are going to defend this case, obviously, and potentially bring it in front of a jury, or if they should, quote-unquote, settle for the cost of defense. So this, again, is just some of these initial questions that need to be asked by both the plaintiff and the defendant. And then, of course, the plaintiff needs to consider the level of the principal target. In other words, is this involving a situation with a municipal lockup, such as a local law enforcement agency, or did this happen in a jail, a county jail that is, or in a state or federal institution. And then from the defendant's perspective or point of view, they need to determine whether this is a custody matter or a treatment matter. And what I mean by custody matter is, did this incident happen when this individual was being looked after, if you will, by a corrections officer, or did this incident happen when an inmate, for example, was being looked after by a social worker or a psychologist? In other words, when he or she was receiving some type of treatment. And then, of course, going back to the plaintiff's point of view, plaintiffs certainly will argue, a plaintiff's attorney certainly will argue that suicide, that is suicide in a jail or some type of lockup, is a leading cause of death. And they will definitely point to a variety of research or statistics that has identified suicide as a leading cause of death. For example, some of the research that I have looked at over the years has identified some county jails that have had anywhere from 25 to 30 deaths in their jail for a one-year period, and a majority of those deaths were due to suicide. And various studies have also compared the suicide rate for the general population with the suicide rate for incarcerated populations, and actually found that the suicide rate in incarcerated populations is actually higher than the general population. For example, research done in Texas found that the suicide rate for the general population was 12.6 per 100,000, and the rate for all Texas jails was 137.5 per 100,000. So this equates to about 11 times as high as the rate for the general population. So no doubt, as I just mentioned, studies have found that the suicide rate in the general population tends to be lower than the suicide rate in jails. And then going back over to the defendant's point of view, a defense attorney can make the argument that general medical conditions are more problematic in an in-custody situation compared to suicide. Certainly, they could argue or would argue that it's the defense that suicide in jail is a rare occurrence, and a custodial death of a detainee confined in a detention facility certainly should not be expected, even though they would argue that it is rare in occurrence. They could also argue that many detainees or inmates enter a period of confinement with diverse backgrounds, and certainly diverse medical, and not only medical, but also mental health conditions. Research from 2015 actually found that 45% of the jail population enters a period of confinement with varying chronic medical conditions, and these can include a variety of medical conditions such as cancer, heart problems, high blood pressure, diabetes, certainly HIV or AIDS, kidney disease, and asthma. So again, a defense attorney could use this line of defense to challenge, if you will, a plaintiff's attorney arguing that suicide is a leading cause of death. Now moving on to the next slide. Certainly important in any civil lawsuit, as I'm sure all of you know, is this idea of foreseeability. And certainly, as I just mentioned or alluded to earlier, a plaintiff's attorney could argue that there are higher custody suicide rates. And certainly, research, as I mentioned earlier, has identified higher custody suicide rates. For example, one researcher has written an article and described that in an average city of 200,000 people, someone will commit suicide every 2 weeks. So if we compare that number to a jail and say for the approximately 200,000 inmates in county jails and police lockups, on any given day, at least one person will kill himself in a county jail. Therefore, the rate of suicide excuse me, in jails would be 16 times greater than one would expect in a city having a population comparable in size to these jails. So again, we're just going back to comparing the suicide rate in the general population to the suicide rate in county jails across the country, and finding that there is a higher suicide rate in jails compared to free society, if you will. And then, of course, the defense would come back and argue that these are questionable data comparisons, and they can even point out that suicide in general and suicide in custody is a rather rare phenomenon, and consequently, rare phenomena certainly are notoriously difficult to forecast due to the low base rate. Also, when you talk about predicting suicide, I really don't like the word prediction. I like to use the word forecasting, because certainly predicting any type of human behavior, right, is quite difficult. With that said, from the defense's perspective, they would argue we cannot predict suicide because social scientists such as clinical psychologists are not fully aware of the causal variables involving suicide, and consequently, without sufficient knowledge of this cause and effect relationship among variables, prediction, or in other words, forecasting, is not possible. And certainly, coming back to the plaintiff's point of view, they could argue about the prevalence of mental illness, particularly that is a problem in our county jails, as I'm sure most of you know. And of course, research backs up this claim. For example, recent research has suggested that anywhere between 6 to 15% of individuals in jails and 10 to 15% of individuals in prisons have severe mental illnesses, and people might even argue that the percentages are higher. Other research certainly has documented the elevated levels of mental illness often found among jail inmates. Recent research has actually revealed that out of 728 male detainees, 6.1% of these individuals met the criteria for a diagnosis of at least one major mental illness, such as schizophrenia or bipolar disorder. And then, of course, coming back to the defense's point of view, they would argue or could argue this problem with a low base rate. In other words, that the rate of suicide in county jails, is quite low. And then also there is this potential problem of false positives. For example, from a defense's perspective or point of view, they could argue that the prediction of suicide using psychosocial risk factors has proven to be quite difficult for a variety of reasons. And one of the reasons, as we just mentioned, would be the very low base rate or prevalence of suicide. Also, a defense could argue that even the most suicide-prone populations, for example, past suicide attempters, individuals suffering from depression and or schizophrenia, have prevalence rates or suicide rates no greater than 1% or 2% of the population. Also, the defense could argue, as I already mentioned earlier, that jail suicide is quote-unquote not predictable. They also could argue that as social scientists, we do not have the tools to predict with any practical consequence who will commit suicide. For example, they also could argue because suicide in jail occurs at such a low base rate, all prediction efforts, again, will suffer from the false positive problem. And just to reiterate my point a little further on this low base rate, from a defense's point of view, of course, in 2002, research identified approximately 482 jail and prison suicides in an inmate population of about 1.4 inmates. Therefore, on any given day, 1.3 inmates died by their own hand. And if we round up the deaths, if we round up to 2 deaths per 1.4 million, the defense might ask rhetorically, who among us can pick out of the one inmate out of about 720,000 who will die by his own hand on any given day? Again, this is just an argument that the defense can use to point out that predicting or forecasting, suicide is quite difficult. Now moving back to the plaintiff's point of view, they could point out risk factors and any type of risk factors that an inmate who committed suicide in jail had. And certainly, I'm sure all of you know the various risk factors associated with suicide in general and jail suicide. But these could include a family history of suicide. It could include a person having a history of some type of neglect or abuse. Of course, having attempted suicide in the past, no doubt having a history of mental disorders, particularly clinical depression, having a history of alcohol and substance abuse, and finally experiencing feelings of hopelessness. And of course, there are many other risk factors, but for the sake of brevity, I'll just stop there. And then, of course, the defense could come back and argue that, yes, the person did have many risk factors. However, at the same time, he or she had many protective factors as well. For example, maybe the inmate was receiving some type of effective clinical care for some type of mental disorder or substance abuse disorder. Maybe they still had a connection with their family, even though they were incarcerated, or they had some type of community support. Maybe there was continuing support from ongoing medical or mental health care relationships and what have you. Also, a defense could come back and argue that could argue this idea of hindsight or omen formation. And I'm sure, as all of you know, there's something called hindsight bias that comes out of social psychology, and this is a term used to explain the tendency of people to overestimate their ability to have predicted an outcome that could not have possibly have been predicted. In other words, hindsight is 20/20. And then also with this omen formation, this is a belief, or the belief that there were warning signs that predicted the suicide. In other words, things that seem obvious after the fact may not have seemed as obvious when it happened, when the suicide happened, or before the suicide actually happened. And of course, whenever something traumatic happens in society, or even amongst ourselves, the defense could argue that there is a need for human beings to attribute causation to something. You know, this idea of attribution theory, right? So essentially, people have a need to explain things, even if their explanations are wrong. And attribution serves a number of purposes. For example, by identifying the causes of a tragedy, such as a custodial suicide, right, where we tell ourselves that we are now in control of our environment and therefore our future. And by attributing something to a tragic situation, right, our world, I suppose, becomes a safer place for us to be in, even at the price of blaming ourselves. And then, of course, there is this argument, if you will, about profiling or who fits the profile. And of course, from a plaintiff's point of view, they could argue that the subject fit the profile of a typical suicidal inmate. So with that said, the question of whether a detainee's past or current behaviors are indicative of a suicidal quote-unquote profile often arises. And this question posed is certainly asserted by the plaintiff in many legal actions regarding custodial suicide. And again, the claim is that the decedent fit the profile and officers failed to recognize it and therefore should be held liable for this individual's suicide. So in an attempt to establish a foundation for such an argument, the plaintiff, I would imagine, will cite a variety of studies suggesting that the decedent characterized the quote-unquote typical in-custody suicide. However, from the defense's point of view, they would argue, or he or she would argue, that everyone fits this profile. Therefore, with that said, the use of a profile can be highly controversial, and the research on suicide points toward patterns and risk factors that correctional personnel should observe. However, with that said, it's important to recognize that a definitive profile of a potential custodial suicide, on which all researchers agree, does not exist. So again, this idea of being able to identify a suicidal inmate according to a particular profile is controversial, and that's good for both plaintiff's attorneys and defense attorneys to know, no doubt. Okay, that brings us to our first question Q&A session. So if anybody has a question, please feel free.
Thank you. We're now entering the Q&A session. Please enter the passcode, which is custody. You may also enter any questions during this time. Please remember that if you're applying for CLE credit, you must attend for the full 60 minutes of the presentation. First question we have: age 18-year-old left with his belt at a medical center that specialty is alcohol and drug rehabilitation by court order. Is the standard of care the same as a jailed prisoner?
Yeah, certainly. The standards of care when it comes to a juvenile detention facility, if I'm understanding the question correctly, in an adult detention facility can have the same standards of care. Nevertheless, there are various organizations, and we'll get to this towards the end of the PowerPoint presentation, do have recommendations that call for evaluating potential suicidal inmates in a different respect. Nevertheless, there can be different standards of care, and certainly this can differ from state to state as well.
Next question: what is the most frequent method of suicide in jails?
Oh, that would be hanging, no doubt. certainly if an individual is going to commit suicide in jail, it's going to be with some type of ligature.
Assuming there was no identification techniques at a detention facility, but the facility makes its best efforts to not allow any negative contraband in the facility, how does this come into play?
So can you just repeat that one more time?
Yes, assuming there was no identification techniques at a detention facility, but the facility makes its best efforts to not allow any negative contraband in the facility, how does this come into play?
Okay, so if a facility does not have any techniques or ways in which they identify contraband, but they make their best efforts to stop contraband from entering the facility, I guess I would, not knowing a lot about a specific case involving this, but I guess I would just have to go back and examine how corrections officers or the jails operated when, at the time, this contraband was allegedly brought into the jail. In other words, did they have some type of procedure, or even if they didn't have any policy that addressed contraband, but did they make an effort to try and identify any type of contraband coming into the jail, either through by an inmate or a corrections officer or even a visitor to the jail? I guess that's the best way I could answer that question.
Next question. Does an inmate that states he has no suicidal thoughts but then self-harms lessen the standard of care for officers?
No, I would say not. Certainly, at least as far as I know, there are no instruments that a corrections officer can use, or for that matter, a psychologist can use to identify an inmate who is malingering or is actually suicidal when in fact he or she says he is not suicidal. If they make their best efforts at trying to identify a suicidal inmate, for example, when they are initially being placed into the jail, then I don't think the standard of care should be any higher or less.
Last question for now. 50s male in a suicide prevention wing of a hospital hangs himself with bedding. Is the standard of care higher in this setting?
That would, I missed the last. Was that in a psychiatric hospital? Did you say?
In a suicide prevention wing, is the standard of care
okay?
higher?
So, well, certainly you do have to keep in mind that we are dealing with individuals who obviously are placed in this type of location because they have either claimed that they were suicidal or even though they had made an attempt on their life. So a judge or a jury might hold a defendant to a higher standard of care if a person had committed suicide in jail with bedding in a suicide wing. In other words, the corrections officers or individuals working in this particular location could definitely be held to a higher standard just for the fact that they are dealing with suicidal inmates or patients.
Thank you. That was our last question for now. You can continue on with your presentation.
Okay. Okay. Well, this brings us to standards of care. And from a plaintiff's point of view, the plaintiffs certainly could argue that the jail or the corrections officers should err on the side of caution, for example, by placing an inmate under constant suicide watch, for example, or they should be taken out of the general population and be held in a suicide wing, for example. However, from a defendant's point of view, they might argue that the individual should be placed in the least restrictive environment. For example, inmates, they might argue, are not to be placed in a suicide watch under constant watch without recreation, distractions, or even companionship. From a defense's point of view, they might argue that such conditions are iatrogenic and that they could even dehumanize, potentially cause more harm to an inmate than good. Also, from a plaintiff's point of view, they could argue that screening instruments or predictors or forecasters should have been used. For example, in the discipline of clinical psychology, there's something known as suicide screening and suicide assessment. And suicide screening refers to a procedure in which some type of standardized instrument is used to identify a person at risk for suicide, whereas a suicide assessment usually refers to a more comprehensive evaluation done by a clinician. So a plaintiff could argue that these types of instruments should have been used. However, from a defense's point of view, they could argue that the quality of the prediction instrument, the effectiveness or the efficacy of the predictive measures of an instrument can be challenged. For example, some psychiatrists are reluctant to use risk assessment suicide tools. Why? They might worry that they are too inaccurate to be useful. They might also worry about the ineffectiveness, if you will, of suicide-specific treatments, including medications. And this next point I want to make kind of goes back to the one question that related to malingering. Some suicidal patients may deny having suicidal thoughts. This might be a conscious attempt to avoid hospitalization or speed discharge, or at the same time it could be an unconscious defense against suicidal impulses. So it's always important to keep in mind that people might either consciously or unconsciously deny having suicidal thoughts. And then, of course, coming back to a plaintiff's point of view, they could argue that the jail should have hospitalized in response to any type of symptom, whether this be some type of medical condition or psychological, if you will, condition, that you should always, again, err on the side of caution and treat each complaint made by an inmate as serious in nature, and therefore you should hospitalize in any response to a symptom. However, at the same time, as I alluded to earlier, from a defense's perspective, they might argue that this inmate is malingering, and they are malingering for escape. In other words, they want to remove themselves from a jail, from the jail, or they want to be placed in a more comforting environment. Certainly, inmates could believe that a suicidal gesture, whatever that gesture might entail, will get him or her transferred to isolation, for example, where he or she feels that they will be safe from the rest of the population and consequently treated more humanely. Also, from a defense's point of view, if we're talking specifically about a jail suicide, a completed jail suicide, they will argue that you should remove all clothes and possible ligatures. And again, this goes back to the earlier question. If an inmate is going to commit suicide in jail, what are the means he or she is going to use? And certainly that is going to be hanging with some type of ligature, either a bed sheets, or clothing, or what have you. Also, from a plaintiff's point of view, they could argue that you should not isolate the inmate, do not isolate, because this can have severe consequences for the psychological well-being of the inmate. And certainly several authorities have argued that isolation can have an adverse effect on an inmate's mental well-being and consequently increase the likelihood of suicide. However, from a defense's point of view, they might argue that this inmate needs to be isolated because he or she is a danger to others, and also there's a need for more checks by corrections officers to be performed on this inmate. Also, oftentimes, from a plaintiff's point of view, closed-circuit television is brought up, and a plaintiff might argue that CCTV should have been used, or in addition to actual visual checks, CCTV should have been utilized by the corrections officers. However, from a defense's point of view, they could argue that CCTV acts as a false reliance, and personal contact is more conducive in terms of helping the inmate with his or her needs. They could also argue that the ability of a corrections officer to effectively watch a CCTV monitor can be affected by environmental factors such as room temperature, lighting, and noise, and what have you. And certainly temperature can produce fatigue, and this would have consequences for a corrections officer to effectively watch over an inmate via a CCTV monitor. From from a plaintiff's point of view, they might argue that inmate monitors should have been used, and certainly in the jail suicide cases I've been involved in, inmate monitors have been used and have not been used, and of course a plaintiff's attorney could argue or make the argument that an inmate monitor could have used, particularly if the jail was understaffed. However, with that said, from the defense's perspective, they could argue that inmate monitors are not dependable. Also, they could point to inmate monitors potentially taking advantage of suicidal inmates or inmates who suffer from some type of psychological illness. Certainly, people who present with some type of psychological illness or are just quote-unquote different than other inmates can be taken advantage of, and a defense could make that argument that inmate monitors or inmates are not to be trusted, if you will. Again, from a plaintiff's point of view, they might argue that road patrol deputies should have been reassigned to the jail if this question of a lack of quote-unquote manpower ever comes up. In other words, if there is a staffing issues at the jail, the jail itself should have reassigned road patrol deputies to the jail. However, at the same time, the defense could come back and argue that, yes, you could have taken road patrol deputies off of the road. However, at the same time, you are diminishing community protection. Now moving on to various organizations that exist, a plaintiff's attorney could argue that the jail should have been certified from these various organizations. And ACA stands for the American Correctional Association. And ACA publishes a variety of recommended standards. They publish standards for juvenile training schools, for juvenile detention facilities. So certainly this goes back to the question about standards, a juvenile facility compared to an adult facility. And this is one of the organizations that I mentioned, that they do have standards for adult facilities and juvenile detention facilities. But again, you have to remember, this is an organization where jails across the country are not required to be certified by, right? But nevertheless, this is one organization that a plaintiff attorney could bring up. The next one would be the NCCHC. That stands for the National Commission on Correctional Healthcare. And again, they have a variety of standards as well. For example, training officers, corrections officers to recognize signs and symptoms of mental illness, and procedures for suicide prevention. And then finally, we have the Commission on Accreditation for Law Enforcement Agencies. And again, for the sake of brevity, we obviously can't get into the heart of all of their standards, but suffice it to say they have a variety of standards that relate to how potentially suicide inmates should be treated in jails. And then, of course, from a defense's point of view, the defense could argue that fewer than 5% of jails across the country are certified according to these three organizations. And now, moving on to causation. From a plaintiff's point of view, and we already alluded to this earlier, but they could argue that there was overall poor screening that was performed in the jail. In other words, there was poor screening related to contraband. Going back to the question we had earlier, there was overall poor screening related to not asking sufficient questions that could potentially identify an inmate who is suicidal or who is at risk of suicidal. In other words, does he or she have risk factors associated with a potential suicide? And then, of course, from a defense's point of view, they could argue about the overall poor predictability of suicidal instruments, and we already got into that a little bit. And then, of course, the impulsivity associated with suicide. For example, there is research that found that 69 of 100 patients had only fleeting or no suicidal thoughts before they made a suicide attempt. In other words, the suicide attempt or actual suicide was quite impulsive. And then, of course, from a plaintiff's point of view, they could argue that corrections officers received poor training. In other words, they did not receive any type of training from the three organizations that we went through, or the poor training led to some type of symptom blindness. Then again, from a defense's perspective, they could argue that psychiatrists have lost 50% of patients. 50% of psychiatrists have lost patients, and 25% of psychologists have lost patients due to suicide. So in other words, individuals who are trained to identify suicidal individuals or suicidal inmates even have problems themselves identifying who will and will not commit suicide. And then, of course, going back to the plaintiff's point of view, they might argue that there was too long between cell checks for a suicidal inmate. However, with that said, depending on when the cell checks were taking place, the defense might argue that 1 minute, 4 minutes, or even 12-minute critical intervals or checks would have made no difference. And then going back over to the plaintiff, they might argue that there was a failure to rescue. However, the defense might argue that the person was already dead. Therefore, in order to preserve the crime scene and be able to properly identify the manner, mechanism, and cause of death, the individual had to be left hanging, even though it sounds quite inhumane. The person had to be left hanging from the ligature or the rope or the bedsheet or what have you to preserve the crime scene, so we could figure out exactly what happened. And I'm not going to spend too much time on this just because we are quickly running out of time. But these are just some statistics I wanted all of you to be introduced to, because certainly when we calculate the suicide rate, particularly in jails, we can actually make it seem quite high or quite low. So the top equation here shows 1,000 jail suicides for one particular year. And if we divide that by the average daily population of 408,000, times that by 100,000, we get 245 suicides occurring in jail every year. However, I can actually make that number, that 245, appear much lower if we go to the bottom equation. So here we're just replacing the 408,000 with 10 million. And 10 million is any individuals who spent any time behind bar. So if we do the math, we come up with a rate of 10 suicides per 100,000. So the top is 245 suicides per 100,000, and the bottom is 10 suicides per 100,000. So depending on which equation or numbers the experts thinks is appropriate. They can make the number seem quite high and quite low. But which way is more appropriate? Well, that's a good question. Some studies have found that 50% of victims were dead within the first 24 hours incarceration, and then a remaining 26% were dead within the first 3 hours. So based on research, it would seem that the equation and numbers on the bottom would seem more appropriate in terms of calculating jail suicide statistics. So I just wanted to introduce this to all of you. And really quickly, this is a case example I worked on involving an individual who was placed in jail and had made a conditional threat of suicide. His incarceration at the jail had been relatively uneventful until about 7 months when family members reported to jail staff that he had threatened suicide if his criminal charges went forward to trial. So he had made a conditional threat. A jail mental health worker conducted what we call an indirect assessment by observation rather than a direct assessment by interview. So the plaintiff lawyer argued that this actually constituted an Eighth Amendment violation of his rights to be free from cruel and unusual punishment, in that he should have been observed and handled differently with respect to his threat. And this individual actually committed suicide in the most brutal fashion by using a razor from like a Bic razor, that you shave your face with, and lacerated his neck and bled out in his jail cell. So the plaintiff's attorney argued that because an indirect assessment of the subject was conducted rather than a direct assessment, that this actually violated his Eighth Amendment rights. And this case was actually thrown out by the judge, but just for the sake of brevity, I can't spend too much time on that. Okay, I'm going to go ahead and stop there. Again, thank you for your time today. I hope you were able to understand me just regarding my illness, so I do apologize for that. And everybody have a great weekend. Bye-bye.
Thank you, Dennis. We are now entering the Q&A session. Please enter the passcode, which is custody. You may also enter any questions during this time. So the first question that we have is, have you studied the suicide of the female driver who was jailed following a stop for failing to signal? Comments?
Have I studied a female driver who committed suicide, like personally? No, I have not. That would be a very interesting case study. Now that I think about it, however, I was involved in a case, I think about 5 or 6 years ago, where an individual, this was a male. He was pulled over and he was ultimately removed from the car by the police officer, and he actually tried to jump out in front of a passing vehicle. In other words, he was trying to commit suicide by having a car run over him. And luckily, the car missed him, and he was brought back to the municipal lockup, not to the county jail. And unfortunately, he ultimately committed suicide in the lockup. And one of the main arguments by the plaintiff's attorney was that the police officer had failed to recognize his suicide attempt.
I think that question was referencing the recent case of Sandra Bland. But the last question we have time for is the standard of care different for pretrial detainees rather than inmates?
No, certainly not. I mean, especially if we're talking about a county jail, right? I mean, a county jail it has an eclectic array of individuals in jail for a variety of reasons. Therefore, I ask the question rhetorically: why should a pretrial detainee or an individual awaiting trial in a county jail be treated any differently with respect to someone being held in jail for some type of a misdemeanor or what have you? No, I would say not, no.
Thank you for all your questions, and sorry that we did not have time to get to all of them. Dennis will be in contact with you to answer your questions. Please remember that if you are applying for CLE credit, you must attend for the full 60 minutes of the presentation. You are also required to complete the survey at the end of the program. In addition to being your best source for testifying and consulting experts for the past 60 years, TASA also offers free interactive webinars, expert written articles, and research reports on expert witnesses such as the Challenge History Report 2.0 and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Dennis Savard for his time and effort in creating this presentation. If you would like to speak with Dennis, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA 1-800-523-2319. One of my colleagues will be following up with you regarding your feedback on today's presentation. This concludes our program for today.